Alright people, so welcome to Jumbo IS and welcome to our lecture series called Daily News in Shorts. In this lecture series, we cover the entire day's current affairs within 30 minutes. This lecture series is very important for you if you really want to clear next year, that is 2027's UPSC examination. It is very important. So make this lecture series a part of your daily routine. It should be a daily habit of yours because we all know that current affairs form the most important portion of your UPSC examination, whether it's prelims or mains. Now, just after watching this lecture, you need to revise it as well because just watching this lecture would be job half done. You'll quickly forget these current affairs, okay? You need to retain them till your examination. That is why revision is extremely important. Now, you can revise these current affairs from the notes provided by us, and these notes shall be shared on our Telegram channel. The link to our Telegram channel is provided in the comment section just below this video. All right then, let's begin today's discussion. But first, let's take a look at the list of topics that we shall cover today. So let's begin. So daily current affairs, 3rd of April, Friday, and here is the topics list. Number 1 on this list is right to be considered for promotion. The thing is that recently, well not recently, but in 2024, Supreme Court passed a judgment that right to get promoted in any public employment is not a fundamental right, but right to be considered for promotion is a fundamental right. Now what's the difference between the two? We'll talk about this. Then the government came out with certain amendments to Insolvency and Bankruptcy Code. It was Insolvency and Bankruptcy Code Amendment Bill 2026. This is the 8th amendment so far made to this law that was enacted in 2016. Okay, so we'll talk about what were the changes that were introduced to make the insolvency and bankruptcy process in India a little more efficient. Okay. Then, well, Supreme Court again came out with an important judgment with respect to foreign arbitration awards, cases that are handled by international foreign arbitration. Okay, we'll talk about this. And recently in USA, there is this debate and an important case with respect to birthright citizenship. Now, what is birthright citizenship? What is the debate all about in USA? How will it impact Indian diaspora in USA? And what are the citizenship rules with respect to birthright citizenship within India? We'll talk about all these issues. So these are the 4 topics that we shall zero in our attention on. So let's start discussing them one by one. Starting with topic number 1, and that is right to be considered for promotion. Now you see, there was this case in Supreme Court in 2024, and that was Bihar State Electricity Board case. Now in that case, well, the person who filed the petition, he said that right to get promotion in government employment is his fundamental right. Now, Supreme Court gave a very nuanced judgment. It said that right to get promoted is not your fundamental right. But yes, when the government is considering about promotion, then everyone should be considered for it. There should be no discrimination. So, right to be considered for promotion is a fundamental right. Everyone will be considered for promotion, and based on their merit, they would get promoted. But you can't say that it has been 2 years and I haven't been promoted. This is your fundamental right. Not every person has a fundamental right to get promoted, but every person has the right to be considered for promotion. This is important. Okay, so what is this entire issue about? Okay, what does our constitution say about this? We'll talk about all these things. So let's begin. This is very important topic from the perspective of Indian polity, a very important subject in your UPSC syllabus. So let's talk about this. So right to be considered for promotion. So what was the context? Well, there was an employee in Bihar State Electricity Board. He filed a petition. In 2024, Supreme Court gave a judgment, and that judgment was related to basically that right to get promoted, right to promotion in any public employment. Remember, it's about public employment, not private sector. Well, this is not a fundamental right, but right to be considered for promotion is a fundamental right. So let's suppose there were 2 employees, both of them got inducted into a particular government company in 2014. Okay, now in 2020 their promotion was due. There were 2 people. Now if only one of them is being considered for promotion, that is discrimination. If both of them are being considered for promotion but only one gets promoted, that is okay. But consideration should be given to everyone. This is very important. There is an important distinction. So this is a fundamental right as per Supreme Court. And where does the Supreme Court, the Honorable Supreme Court, I mean, what provisions of the constitutions were interpreted, okay, to get to this conclusion? Well, right to be considered for promotion is part of our constitution. And how so? How did the Supreme Court interpret that it is part of our constitution? So the right is rooted in the following of articles of the Indian Constitution. First of all, the fundamental right to equality, Article 14. Article 14 says that there shall be equality before law and equal protection of law. So arbitrary denial of promotion opportunities violates this principle. Everyone has the opportunity. Whether they'll get promoted or not, that is not a fundamental right. But opportunity to get promotion, consideration for promotion, this is part of right to equality under Article 14. Then Article 16 Clause 1 clearly says equality of opportunity for all citizens in matters related to public employment. Okay, so in matters related to public employment, there will be equality of opportunity. It is expressly mentioned in Article 16, okay, implied in Article 14. And Article 21 is right to life with dignity. So they said that proper career progression is right to life with dignity. So somehow you interpret it as part of Article 21 also. Though Article 21 clearly says right to life and personal liberty. That's it. It stops there. But the Supreme Court interprets it in such a way that, well, right to promotion is right to proper career progression. Your career is progressing in a proper way. No one is hindering that. That is also right to life with dignity. Okay, if your career stays stagnant with no fault of yours, that is not right. That is not life with dignity. So it has been inducted into this also. Clear? Make sense? Now, what is the legality of this entire thing? Key legal principles. So consideration versus entitlement. This is very important. The Supreme Court makes a distinction between entitlement, that you're entitled to promotion. No, Supreme Court says no. But yes, everyone shall be considered for promotion. This part is there. An employee has no vested or fundamental right to be promoted automatically. However, they have a fundamental right to be considered for promotion if they meet proper eligibility criteria for promotion. Okay, you cannot deny them promotion if they meet all the criteria. Or consideration for promotion. You can deny, but consideration for promotion. This is important distinction. Then the Supreme Court has said who will get promotion, who will not get promotion, that is the domain of that particular department. But everyone should be considered for it. That is, well, a duty of every department. The state has the power to decide when to fill a vacancy based on administrative exigencies, administrative requirements. An employee cannot demand a promotion from the exact date a vacancy arises unless the rule specifically provides so. But the Supreme Court also identified that there are so many promotions pending in various departments of the government. And Supreme Court said that the departmental promotion committees have not been working properly. That is why career progression of various government employees it is not up to the mark. Okay, and because of that, many public employees have grievances. That is there. So therefore, the answer is that right to promotion shouldn't be a fundamental right. Okay, but the solution to this problem, to solve the grievances of public employees, is that departmental promotion committees should sit regularly and keep a track of all employees so that when their promotion is due, they should be given back. This reform should be undertaken. You can't demand promotion as a fundamental right. So this was a delicate balance maintained by not just the Supreme Court, but various high courts as well. Okay. Now, what are the challenges in front of this? First of all, administrative lapses. Inordinate delays in convening department promotion committees lead to employees retiring in the same rank despite being eligible for high posts. That is why, because DPCs are not working, that is why employees have grievances. Stagnation. Lack of timely promotion affects morale, efficiency, right to career progression, which is now a fundamental right. Then this leads to frequent court cases also, because then employees have no other option but to file a case in the court. And courts shouldn't be bothered by these things. These things should be handled at departmental level. Because courts have to handle, there is already so much pendency in our court systems. There are so many pending cases. You can't add up more burden. So this is there. Ad hocism. Frequent use of ad hoc appointments instead of regular promotions. Okay, there should be a regularity. There shouldn't be ad hocism. These are the challenges because of which employees are filing cases. Okay. Now, why is this issue important? First of all, For an efficient bureaucracy, there should be no ad hocism and the morale of employees should be high. Then rule of law, right? To be considered for promotion, timely promotion will ensure rule of law. Okay, state as an employer should be fair and just. That is what rule of law is. Plus social justice also. Proper implementation of promotion rules ensures that reserved category candidates and merit-based candidates both receive their due opportunities without exclusion. So for social justice, this is also important. Okay, reserve candidates should also get promotions. Merit-based promotions from general category should also be there. There should be a proper balance for social justice. Now, what is the way forward suggested for this issue? This is important from the perspective of UPSC Mains answer writing. There should be mandatory timelines. State and central government should adhere to fixed calendar of department promotion committees meetings. They should meet regularly, not ad hoc. Digitization. Use online portals to track vacancies and eligibility automatically to reduce human delays, passage of files. The files remain pending. Use the online system. Judicial consistency. While the Supreme Court has set the principle, the executive must implement it as standard operating procedure rather than waiting for court interventions. Because the Supreme Court has made it clear. Okay, they have made their stand clear. But every time an employee files a case and the department waits for the court's judgment. This is happening every time. We should stop this. Okay, now the court has made their stand clear. Now there shouldn't be any future litigations. That's what the way forward should be. Right? Make sense? All right then. Let's move on to next news item, and that is amendments to Insolvency and Bankruptcy Code. Now, for those of you who have joined us recently or are new to UPSC preparation, you should know what Insolvency and Bankruptcy Code is. Look, suppose I have a company, okay, and my company is functioning well. I took a lot of loan from different banks, right? From State Bank of India, ICICI Bank, HDFC Bank, PNB. There was a lot of debt for expanding my company's operations. Now, due to some problem, well, I'm short of money. And I'm so much short of money that I cannot pay these banks back. At this point, I'm insolvent. And the legal term for this is I will declare bankruptcy. I will declare it legally that I cannot pay you back. I don't have money left. Okay. Once you declare bankruptcy, I would become an NPA, non-performing asset for these banks. Now, these banks are in the business of recovering money also. Now, how would they recover money from me? There should be a proper rule for that. There should be a proper law for that, right? For recovery of money from these businesses. Yes. Now, for that reason, Insolvency and Bankruptcy Code was passed in 2016. Because before 2016, there were many laws for bankruptcy, but those laws had problems. There were inordinate delays. Courts took a lot of time. All these things were happening. So to streamline the process, make the bankruptcy more efficient, make recovery of money for banks more efficient without delays, well, a new law was passed, which was called IBC. Now, there have been 8 amendments so far to this law to make it more efficient with every amendment. Now, this latest 8th amendment again has tried to make it more efficient. So what is this amendment all about? Let's talk about this, okay? So amendments to Insolvency and Bankruptcy Code. So remember, this is the 8th amendment to this law, IBC, which was passed in 2016. All right. Now, why was there a need for this amendment? Well, admission delays. You see, whenever you declare bankruptcy, your company declares bankruptcy, your case goes to National Company Law Tribunal. Okay. Now, in this law, there is a proper timeline. Okay. The case should be resolved within 270 days. It's actually 180 days, but 90 days extension can be given for emergencies. So in maximum of 270 days, the case should be resolved as soon as a bankruptcy is declared. But the problem arrives that whenever the bankruptcy is delayed, the matter will go to NCLT. NCLT takes time to admit those cases and sometimes even rejects them. Okay, then that matter ends there and then. Now, the government through this new amendment has said that you have to admit this case within 14 days. Okay, and you cannot reject it arbitrarily. Earlier that was being done. The only grounds for rejection is that first you'll verify that whether there is a case of bankruptcy or not, whether this person is really bankrupt or not. After that is verified, you have to admit it. So there is a 14-day thing, 14-day limit. Okay. Then, well, there were low recovery rates. Because of these prolonged delays, the money recovered for banks was very low. Then judicial overburdening also. NCLTs were clogged with frivolous litigations, fake cases. This was a problem. Okay. Then global integration. Lack of framework for cross-border insolvency. Suppose the company is registered in Dubai and it has a subsidiary in India. That goes bankrupt. Now you cannot go to Dubai-based company because this is cross-border. Now under IBC with this latest amendment, you can handle cross-border insolvency cases as well. Okay, so this is there. Clear? So there was a need for this. Now it will be done. There was a need. Now what are the key provisions? There are so many, 12 amendments. The bill introduces 12 major changes largely based on the recommendations of Baijant Panda Select Committee. Remember the name of this committee. Based on the recommendations of this committee, this amendment was made. First of all, streamlining 14-day rule for admission. Then, well, sometimes you don't even have to go to NCLT. What happens is that, well, all these banks, they form a committee called Committee of Creditors. And then there is this company. Under IPC, what usually happens is that, well, the company declares bankruptcy, goes to NCLT, and the Committee of Creditors also goes to NCLT, and then the issue is decided by resolution professionals. The thing is that without approaching NCLT, the company can directly go to Committee of Creditors. This is known as Creditor Initiated Insolvency Resolution Process. Okay. The Committee of Creditors would tell this company that don't go to NCLT, we can handle this process all by ourselves. Let's do an out of court settlement. This is called CIIRP. Clear? This can be initiated in cross-border cases as well. So this was done. Now earlier what used to be the case was that all these banks, before approving CIIRP, well, in this committee required at least 66% vote to initiate CIIRP. Now the bill has reduced it to 51%, a lower threshold. So you can easily initiate CIIRP, out of court settlement. So this would be an encouragement. Then more accountability and discipline. Okay, there used to be a conflict of interest between resolution professional. Once the bankruptcy is declared, NCLT appoints a resolution professional which will handle this case. If the case is not being handled properly, if the resolution professional cannot resolve this bankruptcy, then all the assets of this company were sold and whatever money was recovered would be distributed to this committee. This was called liquidation. Now, generally, resolution professional and liquidator were one and the same person. This created conflict of interest. That has been removed. Then appellate timelines. If you're not happy with the decision of NCLT, you can go to National Company Law Appellate Tribunal, where you can appeal against their decision. They also used to take a lot of time. Okay, now there is a time limit for them as well, 3 months, 90 days. Then penalties. Some of the penalties were, well, criminal cases. They have been reduced to civil fines, so that whenever there was a criminal penalty, you filed a new case at NCLT, that again overburdened the system. So you reduce those criminal penalties to civil penalties, fines. Okay, so this was being done. Now, critical evaluation, pros and cons, it is given in your notes. Do go through this. Okay, the pros and cons of this new amendment bill. That's about it. All right then. Now let's move on to next news item, and that would be related to foreign arbitration awards. Now, first of all, you need to know what is arbitration, what is mediation. You see, the thing is that, well, our courts are already overburdened. Now, if someone is doing out of court settlement, the courts encourage that because they don't want everyone to come to them. They're already overburdened. Now, for this, there are different mechanisms created, which are called alternative dispute resolution mechanisms, ADRs. One example of ADR is arbitration. One example is mediation. So let's talk about arbitration and mediation, okay? And then we'll talk about what's the current issue. So let's begin. So foreign arbitration awards. Now look, This is called alternative dispute resolution mechanisms. The courts of India are encouraging it. There are two ways for it: arbitration, mediation. Suppose there is a commercial dispute between two parties, okay? Commercial dispute between two companies related to the contract between them. Now, they can go to the courts, High Court, Supreme Court, or they can go to a neutral arbitrator. That arbitrator will sit down, listen to both arguments, and give a final decision out of the court. Before going to that arbitrator, both parties agreed that whatever will be the decision of that arbitrator would be legally binding on us. Okay, so this is arbitration. There are many foreign arbitrators of the world renowned, everyone goes to them. There is International Court of Arbitration also, and many arbitration centers in Singapore, in Dubai, many, everywhere. Even there is one in India, and India wants to increase its prestige. This is an arbitration. Then what is mediation? Again, the two parties go to a third person, but that third person does not give any legally binding judgment. That third person's role is to act as a facilitator. The decision would come with the mutual discussion of the two parties. He would just act as a facilitator. He would facilitate mutual discussion, and the decision would come out because of your mutual discussion. This is mediation. Now, there are many commercial disputes in India, many commercial disputes. Okay, sometimes the commercial disputes involve a foreign investor and Indian government. Now, most of the times, those foreign governments don't trust us, so they take our case to the foreign arbitrators. Now, those foreign arbitrators give a judgment, and then their judgment is appealed in Indian courts, Supreme Court, High Court, and sometimes even reversed. So these foreign investors are not happy with us, that whatever is the judgment of the foreign arbitrator, you should accept it, but you go to Supreme Court, and Supreme Court admits it, saying that the final judgment right is with Indian courts. This is wrong. Okay, so for this perspective, well, government came out with a new law called Arbitration and Conciliation Act. As per this new law, well, the Supreme Court has also increased the threshold for admitting these arbitral awards. So Supreme Court has said that Indian courts shouldn't just admit these awards. There is a proper procedure, and they have raised the bar very high. So if only these conditions are fulfilled, then only we can admit it. Otherwise, courts cannot even admit the arbitral awards, and both parties have to follow it. You can't just appeal it. The courts will accept the appeal only if certain conditions are satisfied, and those conditions are very difficult to follow, making it difficult to admit these international arbitral awards in Indian courts. That's what Supreme Court wants, so that foreign investors feel comfortable in India, ease of doing business improves. You understand? Supreme Court has reinforced a minimum judicial interference policy, setting a very high bar for Indian courts to refuse the enforcement of arbitration awards passed outside India. This is as per New York Convention. Remember the name of this convention. What is the legal framework for this? There is a law in India. Part 2 of the Act deals specifically with the enforcement of certain foreign awards as per Geneva Convention, New York Convention. Okay, Section 48. This is the most critical provision. It lists the narrow grounds on which an Indian court can refuse to enforce a foreign award. Generally, Indian courts will ask both parties to accept the judgment given by foreign arbitrator. But there are certain conditions in which they will admit the case themselves and refuse the enforcement of that foreign judgment. Those are listed down in Section 48. Supreme Court has said, interpret these properly. Keep the grounds narrow. Historically, Indian courts were seen as interventionists. They always used to accept cases. Recent amendments and Supreme Court rulings have sought to change this perception of India. Okay? So, judicial observation is no review on merits. If you disagree with the foreign arbitrator, you can't just admit the case. Patent illegality defense. The SC clarified that the grounds of patent illegality, error of law apparent on the face of record, is available for domestic awards only, not foreign. Finality of awards. Supreme Court is also saying that international arbitration should be final. In very rare cases, you should admit the case with yourself. Okay. Now, what is the significance for India? Ease of doing business will improve because foreign investors would feel comfortable that in case there is a dispute, we'll go to the International Arbitration Center. Reduce judicial burden. Okay. Making India an arbitration hub. Though there are a few challenges, but those are self-explanatory given in your notes. All right. And now let's move on to last news item of the day, and that is birthright citizenship in India. Now you see, in USA, as per US Constitution, there is a dispute going on. As per US Constitution, if you are born on American soil, you have the right to take American citizenship. Now, many illegal immigrants were misusing this provision. They migrated to USA illegally, then had a child. Since the child was born on American soil, their child would become American citizen. And because their child is American citizen, their path to get American citizenship becomes easier. They were doing this. Illegal immigration was being incentivized based on this. Now, well, Donald Trump wanted to stop this, so they filed a case in Supreme Court, basically tweaking it. Basically saying that you interpret the American Constitution in such a way that only if one of your parent is American citizen, then only you can get this, your baby can get this citizenship. Okay, so listen to me very carefully. And what are the Indian provisions with respect to this? Okay, so birthright citizenship in India. So you see, there are two philosophies behind citizenship. One is called jus solis, which means son of the soil. If you're born on American soil, you will get this citizenship. The other is jus sanguinis, which means by blood. If your parents are American citizens, then only you will get American citizenship. Now, USA, as far as citizenship is concerned, the 14th Amendment of American Constitution basically allows jus solis. And because of this jus solis, well, I told you, American illegal migrants were taking advantage of this. But the Trump administration is interpreting 14th Amendment in such a way that they can convert it into jus sanguinis. The interpretation. US Constitution is very clear, but how you interpret it is a matter that is something that only Supreme Court can do. So they have filed a case to interpret it in such a way that it converts into jus sanguinis. Okay, this is the case going on in USA. Now, if it gets converted into jus sanguinis, the Trump administration is saying that at least one of their parents should be American citizen, then only you will get American citizenship by birthright. Now, if the Supreme Court of America accepts Donald Trump's administration's argument, well, what impact would it have on Indians? Implications for Indian diaspora. Well, there are many Indians who are on H-1B visa or different visas, and they have been on that visa for a very long period of time. In that time period, if a child is born on American soil, generally that child used to get American citizenship. But now, if Trump's arguments are followed, that child won't get American citizenship. So these people are hanging in dry. Then, risk of statelessness. Because if a child is born outside India, there is a proper procedure, detailed procedure for that child to get Indian citizenship. Now, these Indians living on a visa in America, well, they can't follow that procedure, so that their child won't get Indian citizenship, won't get American citizenship. The child would become stateless. Okay? And the other argument is being given by American left. They say that if Indians are not, the talent pool of the world is not welcome in America, America would lose out in science and technology. That's what they say. Because these immigrants have contributed to American innovation, science and technology and all that they say about Indians. Okay, that's a different argument. Now, difference between India and American citizenship. Okay, so what is the principle? America follows jus soli, India follows jus sanguinis. In India, well, your parents should be Indian citizen. Well, the basis is Constitution's 14th Amendment in American Constitution. For India, there is a law, not Constitution, Citizenship Amendment, Citizenship Act. Current rule, anyone born on soil is a citizen. In India, parents have to be a citizen. Evolution since 1868, 14th Amendment was passed in 1868. Well, in India, citizenship is given not as per Constitution, but as per Citizenship Act, and it has been amended many times. So this is a brief comparison. Okay, and that would be all. With that, we conclude today's session. So thank you so much for watching, everyone, and I'm sure it has added value to your preparation. I'm sure about it. Now, your job is to stay consistent, revise the lecture from the notes provided by us, and make this lecture series a part of your daily routine. It's your job to do. All right then. On that note, I'll be signing off with the promise of seeing you again with another set of news items. Thank you, everyone.